This lecture is about the amending power of the Parliament under the Indian Constitution. As we all know, a constitution is a system of fundamental laws or principles for the governance of a nation. This constitution usually states the general principles and framework of the law and the government. A constitution may be either written or unwritten. The amending provision in the written constitution assumes greater importance because it gives chance to successive generations to grow it as per their needs. In fact, the essence of a written constitution lies in its mode of amendment. Framers of a constitution cannot anticipate conditions which may subsequently arise in the progress of a nation or establish all laws which may be necessary from time to do justice to the changing conditions of a community. It is not practicable for a written constitution to specify in detail all its objects and purposes or the means by which they are to be carried into effect, nor is such an exercise considered necessary or desirable. Constitution framers were fully aware that the amending provisions have great importance, and these provisions ensure smoothness and flexibility to the Constitution. In order to avoid the problems which existed in the rigid and flexibility provisions in the amendment of various constitutions, framers shaped Article 368 as a time blend of rigidity and flexibility. That means the amendment of Indian Constitution is neither rigid nor at the same time it is also not flexible. Article 368 provides for the procedure for the amendment of the Constitution. So it provides for the formal method of amendment. As we all know, practically every constitution has some formal method of constitutional amendment. This consists of changing the language of constitutional provisions so as to adapt the constitution to the changing context of social needs. The formal amending process is most significant way of adopting the constitution to changing the circumstances. The formal method of amendment under Indian Constitution is described in Part 20 of the Constitution, wherein Article 368 deals with this issue. Now, what does Article 368 provide for? Let us consider this issue. Article 368, as originally stood, was titled as Procedure for Amendment of the Constitution. It conferred power on the Parliament to amend the Constitution. The Constitution 24th Amendment Act of 1971 substituted the original Article 368. The title is replaced by a new title, Power to Amend the Constitution and Procedure Therefore. The Constitution 42nd Amendment Act of 1976 further amended Article 368 to the effect declaring the constituent power of the Parliament as unlimited and absolute, and excluding interference by courts in excess of the power that is on any ground. Article 368 of the Constitution of India deals with the power of the Parliament to amend the Constitution and the procedure therefore, which I have already told you earlier. For the purpose of amendment, the various articles of the Constitution are divided into three categories. The first category is out of the purview of Article 368. whereas the other two are part and parcel of the said article. It enables the Indian Parliament to amend the provisions of Constitution without disturbing its basic structure. The amendments described in Article 368 are of three types, which I just mentioned a little while ago. One, amendment by simple majority vote of the Parliament. Next, amendment by special majority vote of the Parliament. Then thirdly, amendment by special majority vote with half number of states legislative assemblies ratification. What does this special majority amendment provide? Amendment by special majority vote of the Parliament deserves special mention. Articles which can be amended by special majority are laid down in Article 368 itself. All amendments except those which can be amended by simple majority and must be effected by a majority of total membership of each house of the Parliament as well as 2/3 of the members present and voting. They come under that category. Amendment to certain articles requires special majority as well as ratification by states to then proviso to Article 368 lays down the said rule. Ratification by state means or by states means that there has to be a resolution to that effect by one of the state legislatures. These articles include mode and manner of the election of the President of India. Secondly, extent of executive power of the Union. Thirdly, extent of executive power of the states. Then, constitution of high courts for a Union territory. Next, provisions relating to Union judiciary. Then, provisions relating to high courts. Then, provisions relating to distribution of legislative powers between center and the states. Then, provisions relating to 3 lists in the 7th schedule. And lastly, provisions relating to the representation of states in Parliament. So this is about Article 368 and the type of amendments that could be carried out to bring about a change in the Parliament. Whether this power of the Parliament to amend the Constitution is absolute or is it subject to any limitations? A bare reading of Article 368 gives an impression that the power vested in the Parliament to amend the Constitution is absolute and there are no limitations. There is no indication of any limitation on the power of the Parliament. The Constitution that means did not expressly provide any limitation on the power of the Parliament. Even the Constitution makers did not think it necessary to provide for any alternative procedure such as referendum or a Constituent Assembly for amending the provisions of the Constitution. So therefore, under the Constitution of India, a constitutional amendment should be considered valid provided the prescribed procedure is followed. So, but subsequent developments have proved that the power vested in the Parliament under Article 368 is not absolute, it is subject to limitations. Through the various decisions, the Apex Court has read several limitations on the power of the Parliament, especially the enunciation of the doctrine of basic structure by the Supreme Court in Keshavananda Bharati versus State of Kerala. It has been made very clear that the power of the Parliament to amend the Constitution is not unlimited. So, in my next video, I am going to deal with the role played by the judiciary in actually restricting the scope of the power of amendment of Parliament under Article 368.